Good morning.
Good morning, everybody.
Morning, Judge. How are you
Good
today?
morning, I'm well, thank you.
The way we're going to proceed is I'll have all the commissioners introduce themselves. We have one commissioner, Amanda Perry Carl, who's appearing on speakerphone, but
Okay.
she's here.
All right, good.
And then after we do that, I'll ask you to give a short opening statement, 2 or 3 minutes, and then we'll have Q&A. And then about 20 minutes in, I'll shut that down and I'll give you a chance to make any final statement you'd like to make.
All right, thank you so much.
So we'll get started.
Good morning, Your Honor. Vincent Citro on behalf of the offices of Horowitz and Citro.
Craig Dyer, Public Defender's Office of the 7th Circuit.
Andy Bardos with Gray Rollins.
Amanda Perry Carl's on the phone. I'm Mike Sassa.
Brett Renton with Schatz and Bowen in Orlando.
Morning, Your Honor. Petra Brownlee of the Brownlee Law Firm.
Good morning.
Hello, David DeArmas, Kramer Price and DeArmas.
Your Honor, good morning again. Scott Thomas with Burr and Foreman.
Good morning. All right, well, good morning to all of you. It's nice to see you again. It's nice to be back. So last time I was here, I talked a little bit about some influences on me as a young person and becoming a judge. I thought I would tell you a little bit, another family story, but this time I want to go back a lot further. My fifth great-grandfather was named Elijah Bacon. He was born in 1760, and in 1775 he signed up for the Massachusetts militia. He was put into a command that was led by Washington. He was part of the Battle of Bunker Hill. He was part of the raid on Boston when our troops took over Boston from the British. He took some time off in, I think, January of 1776, came back a few months later, was in Albany, was at Ticonderoga, but ultimately ended up at Valley Forge in the winter of 1777 at 17. I think we've all heard the stories about how tough it was at Valley Forge. In 1778, he left along with Washington's group to West Point. I'd like to think he was one of the 2,400 that crossed the Delaware, but I can't prove that one. But in my mind, he's there. And so he was at West Point mostly until he finished. He was hospitalized at Fishkill and was ultimately discharged in 1780. So I tell you that story because I think of him frequently. I think of a 15-year-old signing up for the military. I think of a 17-year-old at Valley Forge. And I think of a 20-year-old at West Point at the same time Benedict Arnold was plotting to turn it over to the British. And it humbles me because I get the opportunity as a jurist to enforce and defend that Constitution that they fought so hard for. It's critical to me that the foundation and the freedoms that he fought for and so many others fought for are upheld, that the separation of powers is maintained, and that the rule of law is applied. So, thank you.
Your Honor, I had the pleasure of vetting you this time around. And I'm wondering, you went up last time, right? We submitted your name to the governor.
Yes,
Can you
ma'am.
just tell us quickly what that experience was like?
I received a phone call.
Yeah.
We didn't actually go up to Tallahassee that time.
Gotcha.
I think it was very rushed,
Mhm.
trying to get the appointment before he had to leave for Washington. So I had a very nice 10, 15-minute conversation with Governor Scott, which is awesome, to get to actually talk to sitting governor. And he asked me some questions. I thought it went well, and I hope to have the opportunity to go up to Tallahassee this time.
Was it sort of what you expected?
I've gone through the process, as I think all of you know, several times. I went as a county judge, I went to be county, I went to be a circuit judge. So it's, it was similar. As I said, it was a little shortened. I didn't have the opportunity to meet with any of the folks in Tallahassee as a committee, which I had experienced before. But as I said, it culminates with talking to the governor. So if you get to talk to the governor,
Right.
it's usually a good thing.
Yes, it's a good day.
So that was great.
Yeah. Judge, I'm wondering, I'm just gonna dive right in because to me, there's nothing glaring on your application and we've seen you before. Well, besides the fact you went to Lake Highland, but I'll forgive that because I went to Trinity.
Trinity? Yes,
But that's okay, we can put our differences aside. But in all seriousness, imagine for a moment, if you would, that you received the appointment and you all on the court were sitting on bunk for a decision. To see, to determine whether or not you are going to overrule a prior precedent out of the 5th District. And while you're debating that, it's readily apparent that there's another issue as well that you've seen multiple times. It wasn't briefed by the parties, but you know that there's a need for some guidance in the lower courts and with the attorneys. You've heard that this is sort of a hot button issue. They don't really know what to do with it. But again, it's not briefed by the parties, but you're all there, you're sitting on bunk, so you could write an opinion that provides this much needed guidance. I'm wondering how you would approach a situation like that.
Well, it's not our role to give advisory opinions. When you say it wasn't briefed, I would need to see the record, the full record. If it was an issue that was, I'm assuming we've had oral arguments, and maybe they didn't raise it at oral argument, but it was raised somehow. That's different than if it's not raised at all. Advisory opinions are not what we're there to do.
What if it was raised at oral argument out of curiosity, but not put in the briefing, but they mention it at oral argument? Your Honor, I mean, this is also in our favor, and we
Is
need
it
guidance.
preserved? Is it part of the lower court's ruling?
No, because it was never argued so far.
No.
And then can you also just briefly address the outstanding issue that you would be sitting on bond to actually look at that was fully briefed by the parties?
Right, your second point.
Right. Can you talk a little bit about your approach to stare decisis?
Well, stare decisis has its place, but it doesn't have a place in court-made law. It doesn't have a place when we already have issues of reliability, and there's a lack of guidance through stare decisis. I would agree with some of the recent dissents from Justice Thomas it's just a part of the formula that we use, and if it's wrong, if the case is wrong, it's clearly wrong on constitutional or statutory basis, and it's appropriate to overturn it, and it's appropriate to overturn it. It's not an end-all be-all.
Are you referencing Clarence Thomas's concurrence in Gamble?
Well, the Gamble, I think Kaiser, it's a consistent theme, and it was one of Scalia's as well, although there was a little bit of a difference between Gorsuch and Thomas and Scalia, but it's not an easy thing, certainly, but I think that there's a crossroads between textualism and stare decisis, and you don't hang on to a precedent that's not appropriate.
I think that Justice Thomas was talking about stare decisis being overruled if it's, quote, demonstrably erroneous, rather than going through the 4 factors that we're all familiar with that ironically are part of stare decisis, right?
Yes.
So do you think that you'd be more inclined as an appellate court judge to stick with that standard of demonstrably erroneous? Do you think you'd be swayed by that, or would you be more swayed by the factors that we've always analyzed?
Well, the factors are important, and every case is different. I think the erroneous aspect is part of it, but not all of it, and it depends on how long it's been there. It depends upon if it's clearly wrong. It depends upon if it's based in, as I said, judge-made law. We've had a period of time where it may be that judges have gone a little further than they should have in interpreting the law and in creating law, or in rendering decisions out of a purposeful interest or something because they thought it was the right answer. Those aren't reasons to rule in a certain way, and so especially if it's in that category, that's not the appropriate category. And there are, as you said, there are criteria to go through with stare decisis. I would go through those. I would examine the history. I would look at the basis for it, and it would not be a factor that I would automatically follow, or one that would be a last resort.
And one more, I'm sorry to beat a dead horse here.
That's okay.
Do you consider stare decisis, like prior case law interpreting the Florida Constitution, to be different than case law interpreting common law rights, like natural rights, and then as opposed to rights that if you're interpreting a statute. I mean, would you handle stare decisis cases differently based on what they were interpreting originally, or do you think that it should just be uniformly discussed?
No, that's what I mean by the judge-made law. So, you know, if it's something that is a, and I wish I could think of an example because there's so many
Yeah.
that I've looked at, but there's none that are coming to mind automatically. You know, if it's something that has, well, in the evolution of the agency law, I think I would look to, and where we've come from Skidmore all the way to Kaiser with all the other ones in between. You know, you see an evolution there that's a little slower. But if there's a situation where there's been a ruling that, as I said, is wrong, that it's not constitutionally based, or in interpreting the Constitution, it wasn't done in an originalist or textualist manner, it was done in a manner looking for a social reason or a purposeful reason or any of those things. Those would all be part of the factors, but every case would be different, and I get a little nervous when it's, you know, what would I rule? Because as a sitting judge,
it's more your
I
approach
don't
that I
wanna-
was curious about.
Yeah, it's, my approach would be consistent with my beliefs that you gotta look to originalism, you gotta look toward the text, and if those prior decisions did not do that, if they're judge-made, then they don't hold the same power that decisions that are clearly rendered for what I would consider to be the correct reasons. They don't mean the same thing.
Thank you, Your Honor, I appreciate that.
You're welcome.
Your Honor, is the idea there that if the decision, wrong as it may be, is a matter of statutory or common law, there's other ways to redress the error? There's legislature.
Absolutely.
But if
that's
it's-
what you're looking for,
right.
then yes, the legislature is definitely.
But if it's a matter of constitutional analysis, there's no effective way to redress that error.
Correct.
Okay.
It was more eloquent than mine, Scott, thank you.
Well, no, I just
Sorry.
tried to make sure
I
I
was on
followed.
the
I wasn't
fly.
following the breadcrumbs, I'm sorry.
I got to listen. It's always easier to clean up. To change subjects a little bit, as someone who's only done commercial civil litigation since I practiced law, I'm always fascinated how judges have to jump from area to area.
Yes.
And I see, if I'm reading it correctly, that in 2017 you were assigned to the civil division, circuit civil, and you really hadn't been part of your practice area, hadn't been part of your time on the bench. How did you handle that? What was your approach to that area, and frankly, how did it go?
Lots of preparation. We would get binders, especially the civil bar, as well as I think all the bars, they pay attention to when we move, and they pay attention to who we are and what we've done in the past. So I had the benefit of lawyers truly wanting to educate me and help me make the right decision. You know, sometimes they wanted me to make their decision, but a lot of hard work. I think I have a reputation for hard work, and I prepared extensively beforehand. If I felt that the law was well settled and I could make a decision on the bench, I did. If I did not think that, I took matters under advisement. How did I do? Hopefully pretty well. You know, there's a lot of appellate work that comes after a civil case. There are a lot of things that are appealed. I've followed those carefully to see if I went wrong, where I went wrong, and how to fix that. I was excited to be in civil because, as you say, it was a little bit different than what I had done in the past. Having a practice that dealt with family and kind of dealing with domestic relations in civil court, I was certainly familiar with the rules and the process of discovery and those kinds of things. But when you're sitting in a civil division, there are so many different varieties of cases that come before you. You can have a foreclosure, and 15 minutes later you can have a complex civil case that's commercial or construction. I relied on some of my colleagues who had practiced in that area, took them to lunch and hoped the rain. Hopefully it was good. It was a division that I really wanted to be in prior to making an application for a position like this, because I felt that that was one area that had been left a little bit, if I was looking at my application, that would be a gaping hole. And so I filled it, and I was excited to do it, happy to do it. But I'm also happy to be back in domestic. So thank you.
Judge, on that, you mentioned taking a look at your appellate, meaning the decisions that you've come up with that have been appealed, right? If I pull that, and I'll tell you,
Probably.
large number of cases, what do you think is the takeaway that somebody would, by looking at all of that, what do you think should be the takeaway?
Okay. Well, there are a lot of unpublished opinions where I was affirmed, so that's nice too. You know, we're not perfect, and so that was a hard part of the application to fill out, because as I wrote some of them down, I'm like, well, they're gonna see this one or that one. There are some early on where, you know, there's one that sort of haunts me that I didn't hold an evidentiary hearing, and I should have, and the lawyers didn't do that. So, you know, you have some where you just whipped it, and then you have others where, you know, wisdom just came a little too late. But I think that my record is largely upheld, and so I read those and I'm thankful for them, and I try to learn something from all of that. I read the Florida Law Weekly when it comes out, and I try to learn from not only my being upheld or reversed, but my colleagues and others as well.
Thank you.
You're welcome.
Let's do an appellate hypothetical as well. Imagine a case that has been an appeal that has been fully briefed, and the parties then notify the court that they've resolved their differences and settled. There's a rule that allows the appellate court at that point either to dismiss the case or to proceed to decide it. How would you approach that decision? Do you make the parties go through perhaps with oral argument, and do you issue an opinion on a case that really isn't a live controversy anymore because the parties have decided it, have settled it? And in what circumstances might you go ahead and issue that opinion in a case where the opinion really won't matter to the parties?
Well, that's something I've never thought about. As a circuit judge sitting over county appeals, when they settle, that's the end of it. I can say that I haven't taken the time to go back and look at everything and see whether it would be advantageous to continue to have them come back. I may not be. Well, I sat as a associate judge yesterday, but that didn't come up.
It doesn't come up every day.
So, no, it doesn't, and I don't know that I have a good answer for you, except that if there's no issue at all to decide, it would seem strange to me to decide an issue, because I go back to the advisory opinion. That's just not, that doesn't seem to be our role. There may be a special caveat I'm missing, but that feels uncomfortable outside the role we have.
Did you say that you sat as an associate judge on this court yesterday?
Yes, I did.
Okay, and tell us about that
It
experience.
was awesome. It made me really want this job.
Would have been funny if you called and canceled and said, never
Yeah,
mind.
no, never mind. No, it was everything that I had hoped it would be. I was fortunate enough to sit a few years ago, and the difference in, as I was saying, I think to Mr. Thomas, the difference in having done civil and having done a few more areas of law and perhaps maturing as a judge, I think made a big difference. I felt really comfortable. The oral arguments were interesting. Reading the record, preparing was fun. You know, probably not the fun that a lot of people would think, but I really enjoyed it, and I felt welcomed. And I can't talk about the cases, but you know, who knows? Maybe I'll be writing something.
Is there something that you can say that you learned from that process about how an appellate court's work is done, or how you view the law, or try to decide cases? Something that you kind of picked up through that experience?
Well, I've certainly watched oral arguments, so I had an idea of how it would look like when we were out in front of the litigants. But being able to conference in the back was obviously something new. I enjoyed the discourse between us. It was intellectual. It was, you know, it reminded me a little bit of going to lunch with my colleagues now, and where we talk about cases, and you know, you think you can go to lunch and not talk about work, but you end up talking about work. So I I'm used to a dialogue and discourse about issues, but to go from being a judge who has to make decisions by myself in a large scale quickly, it was just such a pleasure to be able to take the time and talk law with the others and to be able to be there as long as we needed to be to discuss things and decide where we were and to debate and try to see where the other ones fell and what we could do to convince them of our point. And so I thoroughly enjoyed it, and I hope I get to come back and be like a substitute teacher. Maybe you'll be able to make me a permanent fixture. That would be wonderful.
How did you go about preparing for oral argument?
A lot. I read the records of all 3 cases. I don't want to get into the details, but there were some that I needed to research a little more than others. There was one that I'm the lead on, so that one, I already started kind of preparing my thoughts on writing an opinion. Came early here and had a chance to chat with the 2 other judges that I sat with, and just not just arrived cold, and then I'll be doing some work afterwards. So lots of reading, lots of researching, reading the cases that they had cited, reading depositions, different perspective from obviously being a trial judge and creating that record instead of being able to read it.
And are you able to borrow law clerks when you do that, or are you on your own doing that?
We had a memo sent to us from the law clerks, which was helpful, but certainly not in totality. You've got to read the record, not a summary of the record.
Is it typical that the sitting judges read the entire record?
I don't know.
Maybe you're just a little ambitious. I'm excited to hear that you did that, but.
No, as a trial judge, there have been times where I had not, I looked up, you asked about the reversals, there have been a couple that I looked at and thought, oh, I did not preserve the record sufficiently, or that might have gone differently, or had I explained a little bit more. And so there are nuances in the record that are not in a secondary source. Mm-hmm. So, and I like the stories of law. That's, I've been a judge now for 12 years, and every day is a new day. I love this job. But, the beauty of applying for this one is that I have a job I love, and here's an opportunity for a job that I think I might love even more, because I like to read, and it was interesting. It was like, I was reading a novel in a way of this person's story and how they came through the court and what they said and what they did. And I felt much closer to the case itself, and I felt my ability to communicate what had happened in the case was more thoughtful and more prepared, having done that, versus possibly just reading a memo and tossing it to the side and said, oh, I got this.
Right.
Who else was on the panel with you?
Retired Judge Jacobus and Judge Brian.
Lambert.
Yes, sorry, thank you.
What's your favorite division in the circuit?
I have a heart for family, and I know that that's not necessarily popular, but I feel that the children that are the, let's say, the beneficiaries of what I do are some of the most important people that I can rule for. They don't have a voice necessarily, and to be able to articulate a clean, thorough opinion, family law opinions are detailed, and to be able to take the time to do that can, I think, make a difference in a child's life. But really, every division has been interesting in different ways. There are pros and cons. I have 2,600 cases right now, so the con of family is the amount of findings that I need to find, the precision that I need to rule with, as well as dealing with the mass numbers. Some of the criminal divisions are fun because the stories you just can't make up. But civil was great because I got to learn some things that I didn't know and to think in a more intellectual way, perhaps. So that's my favorite, but I think all of them have been very helpful to me and have led me to where I am now.
Well, for what it's worth, I agree with your decision in the David versus Kimberly case.
Okay, good.
You put a lot of work into that one.
I did. Every case is important.
That's a good decision. I'm glad you came down on it.
All right, well, thank you. I appreciate it.
And I know all the lawyers, and so So I don't really want the case, but I know you had your hands full. Okay. Well, that concludes the Q&A portion.
Okay.
If you'd like to make any closing remarks or statement, we'd love to hear it.
You know, I think I can just wrap it up in some of the things that we've talked about in the Q&A, which is that my judicial philosophy is both one of hard work and attention to detail generally. You know, some of those appellate decisions are a result of not having the ability to do that with a large caseload. This is the opinion, this is the position that I've worked to achieve. This is the position that I want. This is not a stepping stone. Thanks to Amendment 6, I have at least 21 more years. And this is where I would like to be able to take all of the experience that I have and be able to have a job where intellectually I'm challenged and the time is there to make the right decision with the right research. So I hope that you believe in me as well and that you feel confident in sending me up to Tallahassee. So thank you.
Great.
Thank you for applying.
Thank you for coming.
All right. Have a great day.
You too.